I'm delighted to have been asked to make a presentation on this very important seminar. This presentation looks primarily at the international context for the provisions on judicial conduct in the Judicial Council Act 2019. The 6 general principles on judicial conduct in the 2019 Act can be traced to the same 6 principles in the 2002 Bangalore Principles of Judicial Conduct. So this paper focuses on the background to and rationale for the Bangalore Principles, in particular that they form the basis for a regulatory system to support excellence in judicial conduct and are therefore a fundamental pillar to support judicial independence and confidence in the judiciary. The Bangalore Principles emerged from a suggestion by Transparency International that such a set of principles should be developed. As a result, a group of Chief Justices and senior judges, the Judicial Group on Strengthening Judicial Integrity, usually known as the Judicial Integrity Group, was formed. And they met under the auspices of the UN Global Programme Against Corruption, and after that, in a series of meetings held between 2002 onwards. The rapporteur throughout the development of the Bangalore Principles between 2000 and 2002 was Mr. Justice Michael Kirby, former judge of the High Court of Australia with proud Irish roots, and former inaugural chair of the Australian Law Reform Commission. In 2003, a resolution of the UN Commission on Human Rights adopted the Bangalore Principles, and in 2006, a further resolution of the UN Economic and Social Council, ECOSOC, also adopted them. I mentioned the 2006 ECOSOC resolution because it also invited the UN Office on Drugs and Crime to support the Judicial Integrity Group in preparing a detailed commentary on the Bangalore Principles, and that was completed in 2007. The 2007 commentary on the Bangalore Principles, they're very similar to expert reports and travel preparatoire published with many internationally agreed documents, and these are often cited and relied on by courts, so we might therefore expect that the 2007 commentary will influence the content of judicial conduct guidelines to be prepared under the 2019 Act. Now, it's clear that the general principles on judicial conduct in the 2019 Act can be traced to the Bangalore Principles. The 6 Bangalore Principles are 1. Independence, 2. Impartiality, 3. Integrity, 4. Propriety, 5. Equality, and 6. Competence and diligence. And in the 2019 Act, the purpose and one of the main functions of the Judicial Council is to support and encourage, quote, the principles of judicial conduct requiring judges to uphold and exemplify judicial independence, impartiality, integrity, propriety, including the appearance of propriety, competence and diligence, and to ensure equality of treatment to all persons before the courts. So that list reverses the order of the 5th and 6th Bangalore Principle, but otherwise the list in the 2019 Act is identical to the Bangalore Principles. Now, funnily enough, there's no explicit reference to the Bangalore Principles in the 2019 Act, although there were 1 or 2 occasional references to them during the Oireachtas debates, including by the then Minister for Justice. There is, however, extensive reference to the Bangalore Principles in the Department of Justice's Regulatory Impact Analysis, the RIA, for the Judicial Council Bill 2017 when it was published, and of course that was enacted as the 2019 Act. And the RIA contains an informative account of the domestic context for the enactment of the 2019 Act, the history of it over the last quarter of a century, as well as the international context, including not only the Bangalore Principles, but also the very poor rating that Ireland has received from the Council of Europe's Group of States Against Corruption, the GRECO group. I will mention the GRECO group context later. Of course, the Bangalore Principles didn't just emerge out of the sky between 2000 and 2002. They are in reality, like all good compilations or codes, like the Justinian Code or the French codes or the US codes. They are based on previous work that was gathered together. In fact, the 2007 commentary on the Bangalore Principles refers to 24 existing national codes from around all the various families of law around the planet, and also 8 regional and international instruments that inform the development of the principles. So this is indicative of the wide range of membership of the Judicial Integrity Group. Now, the seminar reminds us, of course, that the establishment of a Judicial Council goes back to the last century, and this demonstrates that the discussion of judicial conduct principles also long precedes the Bangalore Principles. And in fact, the 1998 sixth report of the Working Group on the Courts Commission referred to principles in this area, including the Model Code of Judicial Conduct of the American Bar Association of 1990, which in turn was a revised version of the ABA's 1972 Model Code, and in fact there were previous codes developed by the ABA on judicial ethics. So what we really know is that the codes in this area have been around for a very long time. Now, the 1998 report, which was in fact the group involved in that was chaired by then Ms. Justice Susan Denham, also recommended that it would be advisable to establish a judicial council, and the detailed work on that was done, of course, in the 2000 report of the Committee on Judicial Conduct and Ethics. And in fact, its recommendations have really become the basis and framework for the 2019 Act. One of the small points I would make is that I don't think it's possible to find an online digital version of that 2000 report, and I would ask possibly if the Judicial Council would consider putting it on their website. I think it's an invaluable document and is only available in analogue form. Remember the analogue era? Now, the 2000 report, of course, is important because it did a lot of comparative analysis as well on the establishment of Judicial Council and looked at lots of existing provisions in comparable common law jurisdictions from Australia, Canada, New Zealand and the US. And of course, in the time lag between 2000 and the enactment of the 2019 Act, Ireland has fallen further behind other jurisdictions. Now, I would say that the causes of that delay are no doubt shared between the executive and the judiciary, but whatever the reasons, by 2010, 10 years after the 2000 report, the government had published the general scheme of the Judicial Council Bill, and in 2011, a year later, the judiciary at its annual general meeting agreed to establish two bodies. First, the Association of Judges in Ireland, the AGI, and also an interim judicial council. Now, in the time immediately before the Judicial Council Bill of 2017 was published, the AGA referred to the basic principles of judicial conduct and pointed out that one of its objectives was to promote the high standards of judicial conduct. So the AGI list of judicial conduct standards of which it was aware are pretty much the same as the Bangalore Principles. So I just mentioned this as another example of how well known the Bangalore Principles were. Now, the AGI on its website has also referred to work that was ongoing while the interim Judicial Council was in place, and that it was preparing a guidance document dealing with all of the headings in the Bangalore Principle. Now, I'm not aware of anything that the interim Judicial Council published as referred to by the AGI, and that's a bit of a pity because it would, of course, assist in terms of the transparency of the process leading to what we expect next year in the codes and guidance for judicial conduct. In any event, no doubt the 2007 commentary on the Bangalore Principles will provide very useful background information for the development of the codes under the 2019 Act. Now, it's worth mentioning, I think, that the Bangalore Principles also reflect very much provisions on the judicial function in the Constitution of Ireland. Now, I'm not going to go into the details of this today in this presentation, but I have prepared a paper that goes into those provisions in the Constitution. And all that I'm saying there is that the principles in the Bangalore Principles, the values and principles in the Bangalore Principles are fully reflected in various provisions on, for example, independence and integrity in the Constitution. So I'm just going to make the point, though, that the Bangalore Principles go way beyond what's in the Constitution because they provide for a regulatory framework. And before I make that point and just comment on that. I'll just make a couple of maybe churlish, slightly churlish comments on what we find in the Constitution. For example, the Judicial Declaration refers to the judge carrying out the judicial role without fear or favour, affection or ill will towards any man, really. And you might kind of think, well, you know, that was 1937, but the pre-1924 judicial oath set out in the Promissory Oaths Act 1868 referred to this oath for a judge: I will do right to all manner of people, not man. Anyway, apparently it proved difficult to follow that gender-neutral precedent from 1868. And of course, we all know as well that the Judicial Declaration in the 1937 Constitution not only says that it's made before God, but adds at the end, may God direct and sustain me. Now, the comparable pre-1922 judicial oath or declaration in the 1868 Act did say, had the words, so help me God, but that 1868 Act also provided that those who could and wished to make an affirmation could do so without any religious reference. And that 1868 Act is, of course, 120 years before the Constitutional Review Group had something to say about the religious reference. But the more important point that I want to make about the Bangalore Principles is that they go beyond those statements that we find on integrity and independence of the judiciary in the Constitution. They provide for, really, and they envisage a regulatory framework on judicial conduct. And the final recital to the Bangalore Principles make that very clear, because they say that they are intended to establish standards for ethical conduct of judges, and more particularly, they are designed to provide guidance to judges and to afford the judiciary a framework for regulating judicial conduct. In other words, the Bangalore Principles are not just about a statement of values, but also about a regulatory system. And in answer to the question, the age-old question, who judges the judges, the answer from the Bangalore Principles is the judges. So by and large, the Bangalore Principles, the commentary from 2007 makes the point that judicial control over judicial conduct is consistent with the principle of judicial independence and with the separation of powers. And equally, it's incredibly important to support the confidence in the judiciary that there be a regulatory system for judicial conduct and ethics. Now, I'm not going to talk about what a regulatory system would look like, because Colin Scott is the acknowledged expert on that, and I know he's talking about that this afternoon. But certainly from the point of view of our own history of the rationale behind the Judicial Council Act, we know that one of the main driving forces in favour of it was the need to replace the stark all or nothing of impeachment, which did not provide the kind of confidence building framework that the 2019 Act now promises. So it is very important to see the Bangalore Principles and what they were intended to achieve as aiming at both a sense of transparency, a regulatory framework, and also the prevention of corruption. And as I mentioned earlier, the regulatory impact assessment for the Judicial Council bill in 2017 made the point that we were really being given a very poor rating internationally by GRECO, the Council of Europe's group of states against corruption. And so the regulatory impact assessment made the point that we really needed a regulatory system in order to be able to be in good standing in the international community, particularly the GRECO group. Ireland, as a very long-standing, in fact, a founding member of the Council of Europe, should be doing its best in that respect. And the RIA in 2017 was saying that we needed to have this Judicial Council in operation. And in fact, even though the Act has been passed, GRECO, in its most recent compliance report in 2020, late last year, made the point that without the actual codes being prepared by the Judicial Council, which we expect next year, in the absence of those, even though the Act has been passed and the Judicial Council is set up, and Greco approved the point that work was being done on these codes, but it still had to conclude that its recommendations on standards for judicial conduct remain, quote, not implemented, unquote. So we really need to see those codes in order to send them on to Greco in order for us in the next compliance round and reports to be able to say that we are now in compliance with the standards of excellence that we really expect. Now, I don't have time in the presentation that I'm making here today to go through the nitty-gritty of the Bangalore Principles, but I would make the point that, for example, there are many things that are going to be very familiar to people from a common law background, and the Bangalore Principles, and in particular the commentary, refer in detail to a lot of principles that we would find familiar. For example, in terms of the value of integrity, that's value number 3, there's a statement in the Bangalore Principles that justice must not merely be done, but must also be seen to be done. That's a clear reference to that much quoted comment from Lord Heward, the Lord Chief Justice in England, in the English case, the Queen versus the Sussex Justices ex parte McCarthy in 1923, that it is of fundamental importance, Lord Chief Justice Heward said, that justice should not only be done, but should manifestly and undoubtedly be seen to be done. Now, in the commentary by the on the Bangalore Principles, the Judicial Integrity Group stressed that the ethical requirement for a judge goes beyond being proficient in the law. Being proficient in the law would, of course, mean that justice is done. But the commentary also said that there should be no suspicion as to impartiality, and that the parties involved are confident about the judge's impartiality, so that justice is seen to be done in that sense. In conclusion, we know from contemporary events in Europe and in the United States that an independent judiciary is crucial in maintaining what sometimes appears to be that elusive ideal, the rule of law. The judiciary mustn't hold the budget, may not hold the budget purse strings, and mustn't, but may be the least dangerous branch indeed of the 3 branches that make up a liberal democratic state, but they provide an important check on the other branches, at least when you can get access to the inside of the courts, which the outgoing Chief Justice made a very strong point about recently. And at present, quite a few opinion polls put the judiciary high up the list of trusted institutions. But we also live in a society in which institutions that previously were held in high regard have dropped like stones. Trust can be lost. And we must acknowledge that the judiciary hasn't been immune from scandal. That's also why the Bangalore Principles and the procedures in the 2019 Act for promoting excellence in judicial conduct, not just reacting to judicial misconduct, are so important to support continued confidence in our independent judiciary. Thanks very much for the opportunity to talk here today.